Hello, good afternoon, ladies and gentlemen. Welcome to the SIAC webinar, SIAC Around the World, Global Trends and Developments in SIAC's 2020 Case Statistics. My name is Emlyn Ho, SIAC's Business Development Manager Legal, and I am pleased to be your MC. So some housekeeping matters first. If you are applying for CPD points, please ensure that you remain logged on for the entire session. You may send your questions to the panelists using the Q&A function on the Zoom webinar. As we have limited time, the panelists will try their best to address as many questions as possible. All our panelists for today's webinar are from SIAC. They are Ms. Shweta Biduri, Head South Asia, Ms. Sue-Ann Ma, Business Development Manager Legal, Ms. Michelle Sonnen, Head Northeast Asia, Mr. Eugenio Gomez Chico, Deputy Head Americas, Ms. Perry Wong, Business Development Manager Legal, Mr. Chunyuan Zhang, Chief Representative and Deputy Head China. Moderating this session is Mr. Kevin Nash, Deputy Registrar and Center Director at SIAC. Kevin, please.
Thank you, Emlyn. Good afternoon from Singapore. On behalf of everyone at SIAC, I would like to welcome you to this discussion of SIAC's results from 2020. As everyone would be aware, and coinciding with SIAC's 30th anniversary, 2020 was another big year for SIAC. We reported our highest caseload ever with 1,080 cases, which was a significant jump from the 479 cases in 2019. 94% of these cases were international in nature, and parties came from 60 jurisdictions. And this adds up to more than 100 jurisdictions in the last 5 years, representing a good mix of the civil law and the common law. The total sum and dispute for cases filed in 2020 was $8.5 billion USD, which corresponds to an average sum and dispute of around USD 20 million for each case. And this shows us and tells us that parties are bringing cases of consequence to SIAC. Singapore remains the preferred seat of arbitration for cases administered under the SIAC rules, but as the seat is delocalized, parties are free and can take advantage of choosing to seat their arbitrations anywhere in the world, as well as having those hearings anywhere in the world and, of course, virtually. 2020 was a transformative year for arbitration generally, as we all had to operate through the COVID-19 pandemic. As an institution, we had to adapt and be nimble and continue to administer disputes during the course of the pandemic when many jurisdictions were effectively shut down. Arbitration proved resilient and more important than ever for cross-border disputes. Over and above the case numbers, the panelists here today have been very active in developing SIAC's policy initiatives and our thought leadership. We have the SIAC Academy, which helps train practitioners in some of the procedural tools under the SIAC rules. We have the SIAC module at universities around the world, and we have webinars like this one. I believe that we are closing in on nearly 100 webinars in the last 12 months. When I look at arbitration from a Secretariat standpoint during the course of the pandemic, some of the procedural tools that are really fundamental to what we do have proved more important than ever. Emergency arbitration, expedited procedure, early dismissal, consolidation, and joinder. All of these have proved very valuable for helping reduce the time and costs of arbitration. What we're here to do today, I guess, is to look at the quantitative analysis of the statistics and then give some context and color to what's really happening on the ground. We know these statistics are very heartening and encouraging, but what does it all mean? So that's why we have everyone here who have the boots on the ground. As mentioned, we will be reserving some time for questions, but please do ask your questions along the way. And I want to thank all the panelists for being here, all of whom are arbitration lawyers and really doing important work for SIAC. So maybe let's start with South Asia. Indian parties have increasingly and consistently been choosing SIAC arbitration. So Shweta, what have you seen last year from Indian parties, and what has been the general trend for Indian parties?
Thank you, Kevin. I think last year was remarkable, not only for SIAC, but also in terms of Indian parties arbitrating at SIAC. So we saw a significant jump, from the previous years to 2020. So in fact, there are about 690 Indian parties that arbitrated at SIAC last year. So which is a great number, and also I think testament, to the trust and confidence that they've had in SIAC over the years. We saw total number of 585 cases which involved Indian parties, and the average sum in dispute was about just over $13 million, which is also a significant amount, considering the number of cases. Majority of the counterparties where Indian party was a claimant were actually US and Singapore. So these are interesting figures, if we try and understand the landscape of, where Indian parties are arbitrating at SIAC. So I think it's very encouraging, and also I think a lot of responsibility, on us to be able to continue to do well and take care of the cases that we've been administrating from Indian side.
Shweta, what are you seeing in terms of the preferences? We know that Indian parties have a traditional preference for ad hoc arbitration. Are you seeing Indian parties starting to be more open to institutional arbitration?
So of course, there's been, as you would know, there's been a lot of push in India from different stakeholders, and not just from the institution side, but also from the government side, to move away from ad hoc arbitration to institutional arbitration. So we are now seeing, I think, more openness, while there is a lot more that needs to be done. Particularly when you look at the contracts from the government side, you still, we yet to see more institutional arbitration in those contracts. But of course, so far as international contracts and private parties are concerned, they're definitely more open to it, and in fact are preferring institutional arbitration over ad hoc, and which I think could also be one of the attributing factors to why Indian parties are choosing SIAC, because they're looking for a credible institution and looking for a credible system to resolve their disputes.
Looking at things generally, are we seeing Indian parties sometimes choosing to have a seat of arbitration in India, and to the extent that there's physical hearings when that's possible, choosing to have a venue there? And any comments on the amendments to the Indian Arbitration and Conciliation Act and how the overall scene is looking?
So of course, the amendments that have taken place, and we've seen a series of them in last 6 years, and I think they've been very instrumental in changing the overall scene for India in terms of arbitration, and of course pushing for institutional arbitration. And the most basic, I think, the fundamental change has been now the parties trusting arbitration. So we still had, while the world was moving to arbitration, we still had a lot of Indian parties litigating in courts. So I think that system, because of the measures they brought in the act in terms of the timelines, stricter procedures, they also codified the IBA guidelines into the act. So a lot of significant changes, which has crystallized India's position in arbitration in general. So I think those factors have definitely contributed, and which is why we're also seeing, even in international contracts, where parties are open to having their arbitrations being heard in India. So in fact, some cases where you see Indian seats and see, an international counterparty in Indian related contracts.
I mean, from my standpoint, one of the compelling factors that you see is, as a jurisdiction develops, you can sometimes see a shift from respondent side to claimant side. There's certainly, particularly a new generation of very sophisticated Indian practitioners. I mean, so Indian parties were the top foreign user in 2020. Where does SIAC go from here with Indian parties, and what do you see happening going forward?
So I think, India is very different jurisdiction, I think, as compared to the rest in terms of the scale, and the economy, the pace at which it is growing. So while the numbers are still high, I think there's a lot more that needs to be done, and there is a lot more scope for Indian parties to shift from the basic ad hoc arbitration to institutional arbitrations, to tap into these resources, rather than sort of, of course, the basic criticism that we see around, in terms of resolution of India-related disputes. I think that shift needs to still happen in a significant way. So we still have a long way to go where we can say that we've tapped into the true potential of where we can go from here. So I think, for SIAC to continue to, I think, deliver is very important. And of course, Indian parties, with the experience that SIAC has in dealing with disputes involving the Indian parties, we will see the numbers rise even more in the future, because you've tested an institution, you've trusted an institution, and that will bring you back to the institution. So I think that's where I will see, a lot more of Indian parties, particularly in international contracts, arbitrating at SIAC, because they're looking for neutrality, they're looking for independence, and most important is the cost efficiency.
Agree completely. Sometimes the best advertisement we can do for a jurisdiction is to have a party file a case at SIAC and see the user experience, the advantage, how we manage to control time and costs and overall streamline the proceedings. Thanks, Shweta. Turning to SIAC Americas, Eugenio, thank you for standing in today. Unfortunately, our head Americas, Adriana Usan, had a conflict. I note the time in Mexico City, Eugenio, so we're very happy to have you here. So there has been a lot of talk and discussion about SIAC Americas. If I'm basing this on my own emails, there is a lot of interest from American parties. Could you start by giving us some background on SIAC Americas and perhaps a comment and any observations on the number of parties from the Americas in 2020?
Of course, Kevin, thank you. Thank you very much. I'm happy to be here. Indeed, we are very excited with the launch of SIAC Americas. Over the past years, we have seen a steady rise in the popularity of SIAC among users of the US. In the past 5 years, for example, parties have come from more than 100 jurisdictions, but the US has continued being a top foreign user. And in 2018, US parties topped the foreign users ranking. And in 2020, despite the pandemic and the general uncertainty that abounded in the world, we saw 545 US parties, which is an 8-fold increase from the 65 US parties we saw in 2019. So for SIAC in general, the launch of the SIAC Americas in New York City is an important, very important milestone for the institution's global growth. We chose New York because it is a hub for international arbitration, not only for the United States, but also for Latin American cases that are managed by international firms with cross-border practices in the city. But as you have seen from your email, SIAC is also interested in growing its Latin American caseload, especially with the increased activity, trade agreements, etc., between Latin America and Asia. To date, SIAC has handled cases involving parties from Brazil, Chile, Ecuador, Panama, Uruguay, as well as numerous cases involving the Caribbean nations. We trust that SIAC Americas, while we physically will be in New York City, will serve as a springboard to promote our resolution services and have deeper ties with Northern Latin America, and give them the benefit of having a real-time access to SIAC as we do with other parts of the world. We consider that this move in SIAC's institutional growth is going to be the beginning of a very long-term collaboration and cooperation relationship with our users in the Americas in general.
Yeah, absolutely. I mean, when you see the amount of trade between the Asia Pacific region and the Americas, we are not there when parties are negotiating effectively the midnight clause, the arbitration clause, but Singapore and SIAC start to make a lot of sense. With the current discussion in ISDS, certainly the SIAC investment arbitration rules is something that has potential in Latin America in particular. And Eugenio, I'll just pause there for a second because we have a question coming in for Shweta on ISDS. And Shweta, of course, you have an enormous amount of treaty arbitration experience. So the question is, what do you see happening in the ISDS space in India? Where do you see that going forward?
So I think, in the last decade, India has been going over sort of the review of the whole ISDS mechanism. Of course, it started with the White Industries case. There were a lot of cases against India. It brought about a new model BIT, and then we also saw conclusion of some of those cases, which have now been challenged by India as well. So I think, India is really at the spotlight at the moment, when you look at this space. So there are a lot of reconsiderations that are happening in the ISDS space. So we will see a lot of changes in terms of what India would eventually come out to formulate. So it is in the period of its testing ground at the moment. So I think things will start shaping a lot more in the next 5 years, maybe. We will see how much uptake there is to the model BIT that India introduced. We will see how open would it continue to remain to the treaty regime in general as well. And I think to a great extent also to explore institutional arbitration even in ISDS. Of course, there's a lot of push for institutional arbitration in commercial disputes, but in this space as well, for India to reconsider what are the procedural lapses that they had with the arbitrations that they saw in the last few years. What is it that they can do better, particularly with the focus on time and cost and the efficiency, even in investment arbitration. So I think it's an evolving space, but India will shape it further in the next 5 years.
Eugenio, going back to you, and as mentioned, there's certainly a lot of potential for the SIAC investment arbitration rules in Latin America. I know you've been in discussions with governments, and I think that Adriana and you have pretty much talked to almost everyone in the Americas. Now, I'm noting that you're in charge of an entire hemisphere. I was wondering if you could just speak a bit more on the counterparties that you're seeing, say, with US parties. What kind of disputes are we seeing? Who are the parties on the other side, and what are you doing going forward? What is the plan for SIAC Americas? Because to a certain degree, even in the United States, I mean, there's almost regional tendencies. So whether there's tech coming from the West Coast, life sciences maybe in the Northeast, the Rust Belt manufacturing in the Midwest, if you could speak on some of that.
Of course, Kevin. So as with the CF-wide statistics, in 2020 there was a record number for American parties, and the main counterparties for U.S. related cases included parties from SIAC's top 10 foreign users, which it's common for. This would help explain the number of parties and cases that we have experienced. And such counterparties come from India, Singapore, Hong Kong, Thailand, China, and Vietnam. For the case in Latin America, and I think I didn't mention before the number of cases, but we've also been seeing an upward trend in the number of parties, which doubled from 2019 to 2020, going from 42 parties to 79 parties. And the number of cases involving Latin America also increased. And the most common nationalities of the counterparties in these cases are Morocco, Indonesia, China, Egypt, Canada, Singapore, Malaysia. So a little bit of everywhere in the world. Of course, it's common for there to be an Asian nexus for these cases. And one of the things that this increase gives us is confidence that even when our market penetration in Latin America might not be comparable to other regions like India, for example, the fact is that users are getting more familiar with the institution, especially since the number of claimants from the region has increased. This would indicate that SIAC has been able to generate enough confidence in the users for them to record to SIAC arbitration instead of other legal or ADR choices that they may have. As you said, your question about what sectors are what the disputes that we have seen in the past year, and this is something that the overwhelming response to SIAC Americas, the people, the law firms are very keen on knowing what are these dispute sectors. And I would say that As for the general SIAC statistics, trade was overwhelmingly the most common in the case for the United States for 2020, at least. But in previous years, commercial and corporate were fairly common as well. That said, as you mentioned, some other newcomers are worth mentioning. We're starting to see more tech cases, for example, which I would say is expectable given that many reports that they have deemed Singapore as the Silicon Valley of Asia. And there have been reports, that these may be a trend going forward, that companies going out of Silicon Valley will begin establishing in Singapore. Regarding
that's something that we're seeing generally at SIAC, an increase in the amount of IP disputes. The legislation in Singapore has been updated. We're now seeing SIAC clauses in ICOs, cryptocurrency, these kind of disputes. I think is something for the future. Eugenio, I'm gonna turn over to Chen Yan and look at China now. What did you see from Chinese parties in 2020?
Hello, Kevin. So it is great pleasure to share some data and more detailed information about the cases involved Chinese parties. So in 2020, we have 185 cases involving Chinese parties, and we have 195 Chinese parties in total. So which set a new record in the SIAC's history. So among the 195 Chinese parties, about more than 75% are claimant, and less than 25% are respondents. I believe it is the first time that we have more Chinese parties on the claim side than those on the respondent side. And the average amount in dispute is over 21 million US dollars, which is about 3 times higher than that of the total caseload. So which is remarkable as well. And the counterparties, for the counterparties are widely spread out in 24 countries, all regions, in all 5 continents, not just in Southeast Asia or South Asia. I think these countries or regions include the Singapore, Switzerland, Australia, Hong Kong, Cyprus, Nigeria, Cambodia, India, Canada, and Latvia. I do not have to list them all. And there's another thing that is about 15% of the China-related cases are represented or co-represented by Chinese law firms. So I think that is basically the highlight of the case statistics of the case. I mean,
that's been an interesting aspect for me on the number of co-counsel situations you have with Chinese parties. I can even think of a Chinese law firm in a case where we're administering under a language other than English or Chinese. How about, could you speak a little bit on SIAC's readiness for Chinese disputes and Chinese language disputes? Of course, we have members of the SIAC Court of Arbitration from China. Are we seeing some of those Chinese language disputes?
Sure. But according to the records, I think there's not many the cases are conducted in Chinese, but I think the SIAC has obvious strengths in dealing with the cases involving Chinese parties or with Chinese as a working language, because in SIAC, I think a substantial part of the staff and the legal counsel in the Secretariat are very fluent in Chinese and are very familiar with Chinese culture. So which give us the very obvious strengths to deal with the Chinese users. And also, but I think the challenge part is here that most of the cases at SIAC are governed by the Singapore law or UK law instead of the PRC law. So I think this part just restrict the make it more difficult for the Chinese practitioners or Chinese arbitrators to participate into our proceedings.
Yeah, I mean, sometimes there's cases where English is the language of the arbitration, but a lot of the contractual documents are in Chinese. So the fact that we have 2 legal counsel at SIAC who are administering these cases, who are
Yep.
Chinese qualified lawyers. We have 3 members of the SIAC Court of Arbitration, also qualified in China in case that we need to deal with any of these issues, even when English is the language of the arbitration. Chunyan, so what do you
Yes,
see?
that's true. So we are in the next SIAC webinar, we're going to see the Mandarin speaking colleague from the Secretariat to present the strengths of our case management skills of SIAC.
Yeah.
So which is about the end of this month.
So what do you see? China is such a big and important arbitration jurisdiction, and lots of Chinese parties are choosing SIAC. If you could project forward, what do you see in the future for SIAC and Chinese parties?
I think with the continuing growth of the economy of China, and that we can expect more international arbitrations involving Chinese parties. And I can say that the more and more Chinese parties are getting more and more confident in using the international arbitration as a mechanism to resolve their cross-border disputes. And particularly, they are becoming more and more confident to use to participate into arbitration proceedings administered by a non-PRC institution. So which may so therefore, I think China we have a very good prospect for to do better in the Chinese market of the China. But however, we also need to see that we are facing very fierce competition in the market in China, both from the PRC institution and from the institutions headquartered in the neighboring countries or regions. But anyway, with our strengths on the case management, the language, and our familiarity with the Chinese culture, I believe we are in a very good positions to compete with other institutions.
And having a lot of institutional choice is a good thing. The parties, to a certain degree, are spoiled for choice, and they could choose one institution, have a different seat, or perhaps that they get their first choice of an institution, but then are willing to bargain on governing law. And I think we had a question come in just about the same time as you said it, but perhaps you could reiterate it for the questioner. What was the main governing law in disputes related to China?
I do not have that number for the China-related case, but generally, I think the Singapore law and the UK law are applicable to most of the cases.
Yeah, that's been our experience in the Secretariat as well. Thank you, Chunyan. Michelle, turning to Northeast Asia, as we know, Korea and Japan are important trading partners for China, India, and the US, and many other countries around the world. We see a lot of outbound investment, and they've been SIAC's top foreign users for several years. Which trends are we seeing in Japan and Korea based on our 2020 statistics? What is the story behind the numbers?
Thanks, Kevin. Really excited to be here today from SIAC's Seoul office. That's right, Japanese and Korean parties have been strong users of SIAC, with both countries frequently appearing in SIAC's top 10 foreign users. Like India, China, and the other major economies in Asia, users in Japan and Korea entrust SIAC with their cases because they are confident in SIAC's and Singapore's commitment to neutrality, expertise, stability, and efficiency. Looking at the numbers from 2020, I would highlight 2 notable developments coming out of Japan. The first is that Japanese parties nearly doubled from 2019 to 2020 to reach 46 parties in 2020. And this is consistent with the overall trend that we're seeing at SIAC with respect to Japanese parties. In the last 5 years, the number of Japanese parties has actually increased 400%. So we're seeing pretty big jumps most of the years. Secondly, we saw significantly more Japanese parties as claimants in 2020 as opposed to as a respondent. And actually 80% of the cases, the Japanese party was the claimant, meaning that it was the party that initiated the arbitration. This is actually significant because historically, Japanese parties have preferred to try to avoid any adversarial process. Today, we're seeing the majority of Japanese parties actively pursue the arbitration rather than being dragged into it by a counterparty. These 2 developments are reflective of a broader trend in Japan. Like in India, the Japanese government has increased its efforts to promote international arbitration. Japan has also likely been influenced by its neighbors in Korea, its neighbors in Asia, including Korea, where there has been a concerted effort to promote international arbitration for several years now. In addition, as is the case in India and China, and also the US, the top trading partners are strong users of arbitration and strong users of SIAC. So, as evidenced by the large number of parties that we're seeing from these major economies in Asia, SIAC and Singapore really do provide an experienced, neutral, and trusted forum to resolve disputes arising out of these cross-border relationships. I think we're also seeing in Japan, given the big jump in numbers in Japan, we're also seeing the effects of Japanese parties becoming more familiar with arbitration generally and more trusting, particularly of SIAC arbitration. The more that parties arbitrate, the more the Japanese companies arbitrate, the more comfortable they are with the process, the more they appreciate its benefits, things like flexibility, autonomy, finality, some of the other cornerstones of international arbitration. Real quick on Korea, I would say that the arbitration industry here is a bit more mature. So this is resulting in a strong and sort of steady average number of Korean parties over the last several years. But SIAC remains a preferred institution. Singapore remains a preferred seat for Korean companies for the reasons related: neutrality, stability, transparency, service levels, efficiency, enforceability, and so forth. One last point here, I would also highlight that disputes involving Korean and Japanese parties tend to be high value. So we've got a handful of very high value disputes with amounts in dispute over several hundred million, a handful of those. And then also if we look at the average sum in dispute for cases involving Japanese and Korean parties, the average sum in dispute is higher than SIAC's average overall. So it's about $25 million US for both Japan and Korea, whereas SIAC's, a little closer to 20 million. Yep. We'll talk, I think we're going to come back and talk about sectors in a bit, but this is reflective of the major industries and exports in both countries. Korean, Japanese companies involved in a lot of construction disputes. These tend to be high value and complex. Also the nature of products being exported, high tech, high value, things like electronics, pharmaceuticals, got a big shipbuilding industry here as well. So I think those are some key points that we can glean from the 2020 numbers in terms of the cases.
And you can see an important corridor with the popularity of SIAC with Indian parties and parties in Northeast Asia, Japan, India in particular, Korea, some of those multi-billion-dollar projects. It depends a little bit where we are in the project cycle, but Korean investment into Southeast Asia, Australia, and Asia Pacific generally, that is where you get some of those big ticket major project arbitration. Thanks, Michelle.
Yep.
Sue-Ann, I'm going to turn to you, and I'm going to task you with speaking for Southeast Asia. Of course, you are a Malaysian arbitration lawyer, and we're very happy to have you in Singapore. But one thing that SIAC has really done is positioned itself as a global institution that just happens to be located in Southeast Asia. But there are a lot of important procedural requirements for enforcement in these jurisdictions. Every jurisdiction is a bit different. There's a bit of a different color for how arbitration works. Can you, taking that all together, can you speak to trends that we're seeing for Southeast Asian parties in SIAC?
Sure, Kevin. Thank you very much for the opportunity today to share some of the stats involving Southeast Asia countries. So looking at 2020, we had 3 Southeast Asian countries that were SIAC's top 10 foreign users. They were Thailand on 5th placing, Indonesia 6th, as well as Vietnam 8th. So I'll just start with Thailand first. In 2020, we saw an increase in Thai parties arbitrating in SIAC compared to the last 2 years. To promote international arbitration as a preferred method of dispute resolution for resolving international disputes, SIAC had signed a memorandum of understanding with the Thailand Arbitration Center in September last year. Looking back at the stats in terms of the counterparties, they included parties from the US, Japan, China, and Hong Kong, who are all Thailand's main trading partners. Majority of the cases were commercial in nature, including hospitality and travel, arts and entertainment, and construction sectors. Other sectors included corporate, trade, energy, IP and IT, as well as maritime cases. So that was what we saw from in terms of Thailand. We'll just move on to Indonesia. Last year, we also saw an increase in the number of parties compared to previous years for Indonesia, and more than 80% of the cases involve a non-Indonesian party. The main counterparties were Singapore and Japan, who are also the main trading partners of Indonesia. In terms of dispute sectors, the cases involve various sectors, including commercial, corporate, construction, as well as banking. There were several high-value cases in 2020 relating to construction engineering, energy, commercial, as well as corporate disputes. So that was what we can see in Indonesia. I'll just move on to cover Vietnam as well. So there was similarly an increase in Vietnamese parties that arbitrated in SIAC. More than 50% of the cases that we saw concern contracts entered into between 2018 to 2020. One of the reasons for this increase could be the growth of the economy in Vietnam. It was also reported that Vietnam is one of the few countries that recorded a positive economic growth in 2020 despite the COVID-19. Looking at the dispute sectors involving Vietnamese party cases, majority of the cases in 2020 related to maritime and shipping sector. There were also a few high-value cases involving energy, as well as construction and engineering sectors, corporate and banking. Looking at the counterparties, the majority of the counterparties in these cases involve Singapore. Other counterparties were BVI, Australia, South Korea, as well as Mozambique. Yeah, that was what we saw for the top 3 Southeast Asian countries in 2020.
For my part, I think it's probably important for me to note that, of course, that we have you as a Malaysian arbitration lawyer, in addition to 2 Malaysian lawyers in the Secretariat, an Indonesian lawyer, and we also have a Vietnamese lawyer, which is quite important. We know that in Vietnam, you have to pay particular attention to service, the registration of an award. In Indonesia, the tribunal will need to issue a power of attorney and have Indonesian lawyers stand in their shoes to register the award in the district court. So that's one of the advantages that we have all of you qualified in these jurisdictions that will be administering or lending a hand on these cases. Thank you, Sue-Ann. Moving around the globe a little bit, Perry, if I could turn to you. SIAC just hosted the Middle East Academy. Obviously, everyone on the panel today has a lot to do with this. This is something that lots of you don't see, that this is really the engine here. I was wondering if you could give us a bit of background on Middle Eastern parties at SIAC. What are you seeing, numbers, trends? What does it look like there?
Thanks, Kevin. So in the past 5 years, we've actually seen an average of about 39 cases involving Middle Eastern parties arbitrating at SIAC. Last year, the average sum of dispute was Singapore 33.7 million. So SIAC is actually popular with UAE parties. UAE parties consistently rank amongst our top 10 foreign users. Half of the new cases filed by Middle Eastern parties last year involved UAE parties. So we also actually just signed a memorandum of understanding with the Abu Dhabi Global Market Arbitration Center, and this is to promote international arbitration as the preferred method of dispute resolution for resolving international disputes, and to better serve the needs of Emirati parties as well as other Middle Eastern investors, companies, and businesses in their cross-border projects and investments. So arbitration is becoming, widely accepted across the Middle East region as the default mechanism for resolving disputes arising out of cross-border projects and investments. And Iraq is the latest signatory to the New York Convention.
Right.
Yeah, so, the numbers that we see at SIAC are indeed very encouraging. And coming back to your question, actually on Middle Eastern parties, besides UAE parties, we also do see parties from Turkey, Oman, Bahrain, Qatar, Kuwait, Egypt. And actually in 2020, we saw an increase in Egyptian parties arbitrating at SIAC. So counterparties for our Middle Eastern parties include Southeast Asians like Singapore and Indonesia, and also the big economies of the world like India, China, and South Korea.
Yeah, that dovetails quite well. We have a question on the decline in the number of construction disputes as part of SIAC's overall case portfolio, and that it was quite low at 4% in 2020, and that's partly to do with the enormous amount of disputes that we had in international trade. So it's not really a product of a decline in the number of construction disputes. Of course, there are some projects that are not moving and not being started in the same way, but it is a bit of a consequence of the number of disputes in international trade, and certainly in the Middle East, we see some of these construction disputes as well. Looking at these sectors, Perry, did you want to add on to that in terms of what kinds of disputes? So we know that of the numbers of parties and where the parties are from in the Middle East. How about the sectors that we see from Middle Eastern parties?
Yeah, so for the sectors in 2020, we received a majority from commercial, maritime and shipping, and trade. So this is, actually quite in line with the numbers that you've said earlier. The high value cases involved maritime shipping and trade. We actually also saw an increase in cases involving blockchain or cryptocurrency banking.
Yeah, interesting. Michelle, how about Northeast Asia?
Well, as you alluded to earlier, many of the disputes are arising out of Japanese and Korean trade and investment in Southeast Asia. So for Korean parties, we had 63% of the counterparties based in Southeast Asia. And then for Japan, it was actually over 80% of counterparties were based in Southeast Asia. We also see a lot of Indian counterparties against Japanese companies. And so the reason behind this is, a major type of investment that companies are doing, Japanese and Korean companies are doing in Southeast Asia is actually construction and infrastructure. Japanese and Korean companies often act as contractors in these big projects in Southeast Asia. And so you see a large percentage of the Korean and Japanese cases coming out of the construction sector. This is particularly true for Korean parties, actually, where construction disputes accounted for about 25% of the total cases involving Japanese parties in both 2019 and 2020. I think we're going to talk about our procedures in a little bit, but SIAC is particularly well suited to resolve disputes arising out of these construction disputes because of our time and cost saving mechanisms like emergency arbitration, consolidation, joinder, and so forth. For Japanese parties, we also see a big chunk of corporate disputes. And let's say about a third to a quarter of all cases in the last 3 years. And this is reflective of Japanese investment abroad, where in countries like India or Vietnam, you often see Japanese companies entering into joint ventures or other types of corporate structures with local companies, and then you might have disputes arising out of those types of investments. Another noteworthy sector that I'm sorry, did I interrupt someone?
Go ahead.
Okay, another noteworthy sector that we talked about with respect to the Americas is IP. We're seeing a growing number of IP cases, especially involving Korean parties. And this makes sense because Korea is becoming an increasingly big tech hub in Asia and also worldwide. And then Kevin, again, as you alluded to earlier, I would also highlight that Singapore, being a progressive and arbitration-friendly seat, is an increasingly popular place to resolve IP disputes, especially in light of the legislation that recently clarified that IP disputes are in fact arbitrable. So yeah, those are some of the sectors that we're seeing and some future directions.
So I'm looking. For anyone who hasn't looked at the annual report, I'll just give the general overview of the statistics, and it also helps answer one of the questions. So we had 64% trade disputes. We have a question from an attendee on what kind of hard and soft commodities disputes there are. I think that would shade more to the hard commodities. We also had 8% commercial, 7% corporate, 6% maritime and shipping, and then 4% construction and engineering. But this was partly because of the amount of disputes with international trade, which makes sense because you would have situations effectively where a party is not able to take delivery or not able to perform its end of the contract and perhaps arguing force majeure. Just to any of you, I will open it up to the extent that there are interesting jurisdictional differences in the types of disputes. Does anyone want to speak on the types of disputes from their areas of the world? I will start assigning names, but please do jump in if there's.
Just to add, so of course, figures from India and the general trend in terms of the sector are very similar to what we're seeing at SIAC. So trade, of course, led the way with about 87%, which is a substantial bulk actually, which came from trade-related disputes, which was followed by corporate disputes, commercial, maritime, and we also saw some construction-related disputes in cases involving Indian parties. I think the notable point is that we saw in disputes involving Indian parties were IP, energy, aviation, employment, which I thought were new sectors, and of course mining. So these were some prominent sectors that also stood out. Of course, while trade, commerce, and corporate led, these are also others, that stood out in terms of the variety and the diversity of the sectors that came from disputes involving Indian parties.
Yeah, we have a good question from the audience, and sometimes it's difficult to categorize disputes because sometimes disputes it may be in relation to a construction project, but ultimately it's a corporate dispute, and categorizing this as construction or corporate can sometimes be challenging because the question that we have on IP cases, are these disputes usually self-contained, or is there a tendency that issues of IP law arise along with construction, energy, general trade disputes? And I guess the short answer is both. Sometimes we do have pure IP disputes, and then sometimes you'll have a dispute from a different sector, but this is ultimately an IP dispute where the IP is the predominant element in the dispute. Let's maybe turn to some of the procedural tools that we have in arbitration and how these took on increased importance in 2020. Shweta, if it's okay, I am going to start with you. And just as a bit of background, in 2020, and I think because of the COVID-19 pandemic, we had more applications for the appointment of an emergency arbitrator than any year on record, 20 of these applications. And what is really interesting is the development of jurisprudence on emergency arbitration in the Indian courts. Effectively, there's now a quartet of seminal decisions in the Indian courts. If you, to the extent that you can, could you discuss how emergency arbitration is operating for Indian parties and any view from the Indian courts?
Yeah. So I think to begin with, when we were preparing for this session today and we were looking at the general stats and trends, I wasn't surprised to look that a large number of emergency arbitrations that actually involved Indian parties. And this is despite the fact that we don't, unlike Singapore, have an express provision for emergency arbitration in our Indian Arbitration Act. But the general position, even before the Delhi High Court's decision recently, had been that they were ancillary or indirectly enforced in Indian courts, which to the best of my knowledge, I don't think any other institution's emergency arbitration award has been tested or given teeth to by an Indian court. So I think that had also encouraged a lot of parties, to be able to use this procedure effectively in cases involving Indian parties. So, when you go back to deciding when you need an urgent relief, what are the options that you have? You either wait for the tribunal to be set up, or you go to the courts. But of course, in India, the courts are heavily burdened, and there are a huge number of backlog of cases. So you're not guaranteed of the timeline within which you can get an urgent relief. So the obvious choice and the availability of the emergency arbitrator mechanism, of course, comes handy in cases involving Indian parties. But more importantly, the fact that Indian courts have given teeth to emergency arbitrators' decisions in the past is what is more encouraging to the parties, and they continue to use this mechanism in their disputes involving Indian parties. And I'm personally actually invested to understand how this is going to span out in the next coming months. We have a decision which is pending before the division bench, and we might see it ultimately go to the Supreme Court, where we will have a clearer position in terms of the enforceability of emergency arbitrator decisions without there being any specific amendment taking place in the Indian Arbitration Act. But speaking of the recent Delhi High Court decision, it has gone on to say that where you have an emergency arbitrator decision in a India-seated arbitration that has the same force as a Section 17 order under the Indian Act. So I think it is, the jurisprudence itself has really strengthened the use of this provision, particularly in disputes involving Indian parties. So it's not only that we have this provision available, but it's also the need of the hour, particularly in disputes involving Indian parties, to have this mechanism where they can get a quick relief, and you get your arbitrator appointed in one single day and guaranteed decision within 14 days. Yeah.
And just to help distill it for the audience, so the question is whether or not this would be under Section 17 or whether you make an application under Section 9, whereby the Indian court would give relief in the same terms as the emergency arbitrator. Is that what the general progression of the jurisprudence has been?
Yes. So what happened earlier, before the current case, the Amazon case in question, is that parties usually would get an emergency arbitrator's order from SIAC and would file the Section 9 before Indian courts on the same grounds as they've got the EA order. So, and then the court will give teeth indirectly without having to enforce the EA order directly, will grant the same relief in a Section 9 application as it did, as was given by the EA, effectively on the same basis. The development has been in the recent cases that there is no Section 9 application, and they have tried to directly enforce it under Section 17. So which is actually a huge, development in terms of how EA orders are looked at in Indian courts and the enforceability of EA orders.
I'll just, and some quick takeaways from my perspective in Singapore. What have we learned about emergency arbitration during COVID-19? What we always knew is that you can make these applications at 3 in the morning. Emergency arbitrator orders in Singapore are enforceable for Singapore-seated arbitrations and foreign-seated arbitrations, so they're enforceable as an order of the High Court. We have specific provisions in the SIAC rules that contemplate hearings by video conference, so this is what's happening in SIAC arbitrations. And I guess for a large part, that most of these emergency arbitration orders are status quo orders. So if you haven't used emergency arbitration before, what an emergency arbitrator is doing is just keeping everything the same until the tribunal, when constituted, is able to deal with the order. What I find really interesting about Singapore, because I suspect that Singapore, if you look at all of the administering institutions we have, I suppose 7 administering institutions in Singapore now, there's probably been more emergency arbitrations here than anywhere in the world. And what's very interesting from a tactical and strategic standpoint is how, because the legislation provides, if the institution is unable to act effectively. So if a party needed, in a Singapore-seated arbitration, needed a reliefs against a third party or ex parte relief, they could potentially make an application to court. So we know from jurisprudence in the UK, you can't forum shop, but these institutions are designed to work, or these provisions are designed to work with applications to court. We had a question about what are some of the popular procedures during the course of COVID-19, and Chinyan, maybe I will turn to you for a discussion on expedited procedure. Expedited procedure is that mechanism that has kind of really defined SIAC as an institution doing things fast and cost effective. What have you seen for Chinese parties, and any comment on expedited procedure generally?
Okay, thanks, Kevin. So I think we can start from the statistics of the EP. case of the 2020. So I think expedited procedures remains to be a popular procedural tools for SIC users. So in 2020, SIC has received 88 requests for EP procedure, of which 37 requests were accepted. I think since 2010, SIC has received a total of 622 EP applications and has accepted 361 requests. So that is a remarkable numbers. As to the EP cases, so I studied the records. I found that the most of the EP applications are made under the Rule 0.1a, so which is based on the aggregated amount of dispute. So about 80% of the applications are made under this ground, and about we still have quite a few applications are made on the other two grounds. So which is the parties agreement, parties agreement, and also the exceptional urgency. So I believe that SIC rules has provide a very framework for the parties to apply for the expedited procedures to save their time and costs.
Yeah, and particularly important during COVID-19 when companies might be a little bit less liquid or just not wanting to have a dispute on your books for a long period of time. That ability to get an award in 6 months is a big advantage. And certainly when we're looking at these cases and deciding these cases, most of the action is on the basis of the sum and dispute, but it's important that these are really just the threshold requirements.
Yes,
Quantum doesn't necessarily correlate with complexity. So you can have a dispute under $6 million, but that doesn't necessarily mean that it's going to be appropriate for the expedited procedure.
Yes, and also that I think the rule 5.3 also provides that the 5.3 also provides that the procedures the relevant rules of the SIC rules should apply even in the cases where the arbitration agreement contains contract terms. I think this provision is interesting, but it also sometimes may be challenged in some jurisdictions like China, like what happened in the Noble Resources Court cases. But anyway, I think SIC I think the rule is flexible enough for SIC to manage this situation and to ensure the enforceability of the arbitral award.
Yeah, what Rule 5.3 really does is give effect and makes things a bit more clear, more fortification, if you will, following the Singapore decisions in AQZ and ARA and BXS and BXT. Thanks, Chin-Yun. Michelle, we highlighted it to a certain degree, but some of these big ticket construction projects in Northeast Asia, could you talk a bit about consolidation and joinder and what these provisions are meaning to parties in your jurisdiction?
Sure. So I'll start first with the numbers. In fact, we did see an increase in the number of consolidation applications in 2020 involving Korean and Japanese parties. But consistent with the trend with Japan in 2020, there was a huge jump in the number of applications filed in cases involving Japanese parties, actually a 500% increase compared to the number of applications made in 2019 compared to 2020. So again, this reiterates the same narrative that Japanese companies, Japanese parties becoming more knowledgeable about SIAC arbitration, more experienced, perhaps even more assertive in their cases. And it also highlights the need for efficiency, for controlling time and cost. Consolidation and joinder are very useful tools because they allow related disputes for the case of consolidation and related parties using joinder to be heard in one forum. This is important because it's going to reduce the risk of inconsistent decisions in different forums. It's also going to save a lot of money if you're not having to litigate the same or similar issues in various different forums. So very important tools, especially if you're talking about high value, complex cases like construction. Construction cases, you're going to have a lot of related contracts with owner and contractor, and then contractor and subcontractor, and subcontractor and subcontractor going down the line. So in these types of big ticket cases, using Kevin's language, you're going to see a lot more consolidation and joinder, and they're going to be both very, very useful tools.
Yeah, definitely. And for me, the big takeaway that I get from you is and that we see in action is that you, as you say, that you don't require there to be the same parties. So you can go all the way down the line. And I think this is particularly helpful because sometimes parties will draft specific consolidation provisions within the arbitration agreement within a suite of contracts that, because the SIAC rules or SIAC provisions on consolidation are quite broad, it allows parties to use the SIAC model clause, and then depending on the dispute can then apply for consolidation. Sue-Ann, another important procedural tool that we have is the ARB-MED-ARB protocol. We've certainly heard a lot about mediation with the Singapore Convention, and there is, to a certain degree, a culture of mediation and conciliation in Southeast Asia. What do you see as the benefits for adopting this protocol, and how is it working in action?
Right. So I think that there are several benefits to the ARB-MED-ARB protocol that we have jointly introduced with SIMC. One of the key features that we would like to highlight is that given the SIAC and SIMC are like sisters organizations, so parties can move seamlessly between arbitration of SIAC and mediation at the SIMC. There is also a complete flexibility over when and how parties elect to mediate. Although under the protocol, it provides for a default procedure, but parties are free to refer to the dispute to mediation at any time during arbitration, taking into account cost saving as well as strategic reasons. Another key benefits would be that by going for the ARB-MED-ARB protocol, it can also quickly bring a respondent to an arbitration and perhaps facilitate a genuine settlement faster than the lengthy negotiations. I think sometimes arbitration can be a catalyst to settlement, so it can actually force parties to actually flesh out and realistically assess their claims and defenses and actually taking negotiations seriously. One of the other key benefits is also that if mediation is successful, parties can actually convert the settlement agreement into a consent award that is then enforceable under the New York Convention. So I think there are a lot of benefits that parties can consider when thinking whether they would like to opt for this protocol. On the stats as of 9 April 2021, we saw that there were about 23 ARB-MED-ARB cases, including parties from BVI, Cayman Islands, India, Japan, Singapore, Switzerland, Thailand, and the UAE.
So what I think from my experience in the Secretariat is that it is good to use this Singapore clause. It is very low risk to try mediation because if the mediation doesn't work within the context of ARB-MED-ARB, you have a tribunal standing and ready to go. I have seen some very contentious cases that have ended up being able to be settled out, get that mediated agreement in the form of a consent award. And really now there's the best of both worlds. You have MED-ARB through the Singapore Convention, ARB-MED-ARB through the ARB-MED-ARB protocol, leveraging off 168 signatories to the New York Convention. So it is really a good binary regime. And I see one of our attendees today, one of the doyens of Singapore arbitration, I believe his or really position that he puts forward is that tribunals in the CMC should always be asking parties whether they're exploring mediation. So parties may be doing it anyways, or you can formalize it through MED-ARB or ARB-MED-ARB. Perry, turning to you and the defining topic for 2020, virtual hearings. We've all had to adjust. Arbitration had really prepared for this, but not going fully virtual. Can you comment on what SIAC has seen in terms of virtual hearings and how it's being used?
Sure. So in 2020, 53% of our merits hearings were conducted virtually, as compared to the 20% which were held physically and 27% which were held as hybrid hearings. So in comparison, 2019, we actually only saw 5% of merits hearings conducted virtually, 90% of hearings were conducted physically, and only 5% of merits hearings were hybrid hearings. And in 2018, it's consistent with 2019 in the sense that 96% of merits hearings were physical hearings, 4% of merits hearings were conducted virtually, and there were no hybrid hearings at all.
What's very interesting, we're quite lucky in Singapore because we do have physical hearings underway or hybrid hearings. So we've had some cases where you may have the co-arbitrators are participating virtually. You have the presiding arbitrator and both sets of counsel present in person in Singapore. And with virtual hearings, I suppose what we're seeing is that tribunals are being very cognizant of due process, the tyranny of time zones. How do you deal with asynchronous hearings? How do you deal with asymmetry in terms of hybrid hearings? So some jurisprudence developing from the Singapore courts and also the Austrian Supreme Courts. But I suppose we're already having a small virtual component to arbitrations before the pandemic, but now we're seeing a really advantageous mix of all three branches. Thank you, Perry. I guess the other defining procedure from COVID-19 is early dismissal, particularly in the context of force majeure. There's a lot of cases where there's no dispute that the contract wasn't performed, and then the argument is, well, I couldn't because of the lockdown. Eugenio, you have a lot of ISDS experience, and we know that we borrowed our early dismissal provision from Rule 41.5 of ICSID. Could you just give a bit of comment on early dismissal and how that might apply to the Americas as well?
Exactly, Kevin. As you said, we have this early dismissal mechanism that builds off the Rule 41.5 of the ICSID rules, and this would be very familiar for parties in the United States because it's very similar to the summary judgments and in litigation in the U.S. And with this mechanism, party may apply for the tribunal to strike out a claim or a defense that is manifestly without any legal merit or manifestly outside the jurisdiction of the tribunal. This, of course, is very important when you want to save time and cost in the arbitration procedures, because, as you said, with the COVID pandemic, many cases there's really no dispute there, and then the tribunal will be able to strike out any number of claims or defenses instead of going all the way with the procedure until the end. And what SIAC has done, what SIAC has done in this case is codify in the rules this opportunity for the parties, that it goes in line with all of our efforts to make our services and our procedures as time and cost efficient as possible.
Yeah, and we, Eugenio, with Adriana, you and I, when we're speaking to users in the Americas, we've certainly seen a lot of interest in early dismissal, and then also that extra limb that we have in the SIC investment arbitration rules, so effectively manifestly inadmissible. What I think has been important about COVID-19 is how parties are getting more sophisticated, and there's been a maturation process with the SIC rules, because now many of these provisions are being combined together. And so the institution has to face important questions. Well, what happens if we need emergency arbitration arising out of multiple contracts, or we need to join an urgent decision on joinder before emergency arbitration? And these are all things that the SIC court is able to decide on an expedited basis. I will put it to any of you, noting that we're getting a bit short on time and we want to be able to answer some of the questions. So what do you see for SIC going forward, whether it's your jurisdiction or generally, a little crystal ball gazing, extrapolating the statistics? What do you guys see?
Kevin, if I may go
Please.
first. Yeah. So I think one is what we are likely to see, and second is what we would want to see. In terms of likely to see, I think from Indian parties' point of view, we will see more uptake of the provisions being used. Of course, everyone mentioned about early dismissal, expedited procedure. Consolidation is still widely used. EA is very popular, but we are likely to see more use of all of the other provisions as well. What I would like to see is really a use of SIAC investment arbitration rules. I think that will truly be a game changer for the investment arbitration regime in India. and it will address some of very important questions of timelines and how government response in these investment arbitration, they need to be tackled within the procedures itself. And an interesting development of where you can have amicus and third parties submissions being taken on board in these arbitrations. So these are two important takeaways from me personally, that one that I would see from Indian parties in the future, and of course in the investment regime in particular for India.
Thanks, Shweta. Anyone else with observations?
I'll say a few crystal ball gazing thoughts on possible sectors that we're going to see more of. I think some interesting sectors that I've been hearing comments on, we might be seeing more gas pricing disputes. This is something, that can, especially in North Asia with Korea, Japan, and China being major players in the LNG field, and then more long-term contracts, and then the disputes that arise out of the gas pricing clauses. So we actually are working on having a webinar on that in the coming months, so everybody stay tuned for that. Another interesting thing that we might see is, with Korea becoming really like the entertainment hub of the world, are things like, BTS going to result in entertainment arbitration arising out of, things like their concerts or licensing deals and whatnot. So, maybe we're going to see a whole BTS sector in our pie chart next year. Other industries, I think this was already mentioned earlier, cryptocurrency. Where is that going to go, and what kind of disputes are going to arise out of cryptocurrency and other fintech issues? And so I think it's all very exciting to watch in terms of what types of disputes we're going to be seeing in the next few years with the new technologies and new industries.
I mean, you guys, it's very interesting for me as well. You guys have outlined some of the sectors and then the new sectors. It's really in that pie chart, it's the other section that is the most interesting. So obviously there's the traditional sectors where we're always going to see arbitration. So whether it's hospitality, life sciences, cryptocurrency, entertainment, and we've seen disputes in all of those. That's where it's interesting to see how arbitration is going to develop. We have a few questions on the appointment of arbitrators as well, and I wondered if anyone wanted to comment on diversity in our appointments for gender and age in particular. I think that we do release diversity stats in terms of the institutional appointments. Does anyone want to comment generally on SIAC's priority on appointing diverse arbitrators?
Kevin,
yes.
Maybe I can throw that back. Oh, okay, go ahead, Eugenio. I was going to say Kevin might be the best person, but Eugenio also.
Well, what my comment was going to be that one of the things that the pandemic interestingly helped us is to appoint arbitrators from far away, because in the past, for example, for smaller cases, it was very difficult for us to appoint arbitrators that were not local because of the increased cost of traveling, the cost for the tribunal to have the hearings in person in different countries, etc. But now with the shift to virtual hearings, and that is becoming more and more common, we are able to appoint arbitrators from far away, and this is of course having an impact in the diversity, not only diversity in national origin, but also perhaps in diversity of age, race, gender, etc. And we at SIAC, of course, we have these commitments with diversity in all kinds of diversity.
Eugenio, I couldn't agree more. And the reason why we want to appoint diverse tribunals is because it makes for better arbitrators, and because our user base is so diverse. That's why we're prioritizing diversity, because it's important, because we get better tribunals because of it. So it's both visible and non-visible diverse characteristics, the intersectionality of these characteristics. And what I think we've done overall, exactly as you say, is we've made a much bigger tent. We need to look no farther than all of the attendees from around the world, some of whom are up, Eugenio, in your jurisdiction in the middle of the night to attend. And that's really been one of the big advantages of COVID-19 and this move to the virtual space. I just quickly will touch on another question on the appointment of arbitrators. There's a question about the number of appointments versus the number of cases. I think one advantage that we have in terms of saving costs in particular is we have a default mechanism for a sole arbitrator. What we've seen in SIAC during COVID-19 in particular is that sometimes parties will file, then maybe get back to the table and will be able to reach a settlement. I think that's what we're looking for as an institution, is that we want to resolve disputes. So if parties are able to come to a settlement thereafter, then I think that we've done our job as an institution. Sometimes disputes will go to an award, or it may go to other forms of dispute resolution, but it's really that sole arbitrator default in terms of our number of appointments. I see that we're at time here. I want to thank all of you, all of our panelists very much, and all of the attendees today. All of my colleagues, they all come with an enormous amount of arbitration experience. Please do reach out to them anytime of day. My understanding is that SIAC Americas is running 24 hours a day. We have Eugenio in Mexico City, Adriana in Singapore, but of course you will both be going to New York. And so thank you, everyone. It was really our pleasure to be able to be involved in this discussion today. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Okay, thank you all for that interesting and insightful session. We hope to see you at our future SIAC events. Have a lovely evening and stay safe, everyone.